Okay, hello everyone. It's almost noon here on Monday, May 18. My name is Joe Schaefer. I am an employment lawyer with the law firm of McDonald Hogan Bayless, and I'm also the president of the board of the Unemployment Law Project. So here we are with our weekly webinar here to answer your questions. We're here every Monday at noon. We're here to answer your questions about everything unemployment related during the COVID era. Today, as usual, we have with us John Tierpak, who is the Executive Director of the Unemployment Law Project, and Ann Paxton, who is a staff attorney with the Unemployment Law Project. So please, I will now turn it over to John and we'll get started. Thank you.
Hi, good afternoon. Welcome. The whole unemployment system has gone through some incredible changes in the last few months. A few things that have changed, it kind of goes to what's been introduced to address the current emergency. Unemployment law projects and nonprofit laws, we've been around since 1984. We advise and represent people on their unemployment claims. We have a website, and you can feel free to contact us individually. We have offices in Seattle and Spokane, and we did over 700 hearings last year and advised countless other people with their claims. The big thing, in terms of changes we're seeing are changes to basic eligibility. In regular times of unemployment, you have to have worked 680 hours in your base year to qualify for a claim and have a qualifying separation and be able and searching for work. So you would apply online or by phone. In-person applications and paper applications are long gone. And a typical claim would have 26 weeks of benefits. And you have the obligation of filing each week to report if you've had any changes in your situation, any income, or any inability to work or look for work. So that's been the way it's been for many years. There's been, of course, rule changes over the decades. The program got started nationally in 1935 under the New Deal. And of course, it's been through many changes since then. So what we're dealing with the COVID crisis are new rules that have adapted some of this. So old rules are in place. The job search requirement has been relaxed. People must be still able and searching, able to work. However, the requirement that a person make 3 job search contacts a week has been relaxed since March. Although we've had many calls from people who are being denied for that reason as well. So the implementation of the program has been problematic, and they're way behind on the claims. Most of the calls we're getting now are about people who simply cannot claim, cannot apply, cannot finish applications, or have made an application and are pending. So it's been very frustrating for many people. So basic scenarios for getting unemployment is a layoff. That's when an employer basically tells you, we have no work for you. It could be temporary, it could be permanent. It is a situation in which unemployment claims are usually not disputed because both sides will agree as to what the issue is. Voluntary quit is more difficult. There's a list of 11 reasons for good cause quitting. A few of them include medical reasons, safety reasons, illegal activities at work, as well as pay reductions of 25% or more. There's also quits for what I would consider more personal reasons, that you have to deal with a domestic violence situation and must quit your job, or if you quit to move with your spouse to an area far away from your work site. Those may be good cause for quitting. And then as far as the termination go, if you're fired from a job or discharged, to have benefits denied, the employer must show there is actual workplace misconduct involved. And many of our hearings that we've done over the years have been on this issue, as well as the quit issues. And so voluntary quit is very controversial. Of course, employers will disagree of whether they really have unsafe work conditions, for example. And then with the termination, there's often disputes regarding what a person actually did and why. So, Anne, I don't know if you want to jump in here and take over. These are more detailed analysis of the PUA and PUC and PEUC, which are new benefit programs that were added since the COVID crisis.
Thank you, John. So if anyone who has listened to our webinars before has heard some of this rundown, there's also some new elements that have just been added in the last week or two. It's kind of a fast changing scenario. First of all, the biggest element that has been added to federal coverage in response to the COVID-19 pandemic is pandemic unemployment assistance, which significantly expands eligibility, as John mentioned, so that now gig workers, independent contractors, people who are looking for part-time work, not just full-time work, people who have less than 680 hours can qualify for benefits once they have not been qualified or denied benefits, regular benefits by the state. So that's an important thing to keep in mind. In order to receive PUA, you do have to be denied regular benefits by the state. The federal law, the CARES law, has set up an unemployment insurance benefit floor, which in Washington state is the average, half of the average benefit paid, $235, plus the $600 per week, which is under a separate program called the Pandemic Unemployment Compensation, PUC. That is added to both regular benefits being received and to benefits under the PUA. And that is extending from late March to July 31st. So there's about 3 months of extra benefits at $600 per week under that program. In addition, and this is just to recap what we've talked about before, there's the Pandemic Emergency Unemployment Compensation, PEUC, which is an extension of 13 weeks of the benefits under PUA as well as regular benefits. And that puts the total number of benefits available to 39 weeks. The new program that has just been authorized is the extended benefits, which will add an additional 13 to 20 weeks beyond the emergency benefits once those have been exhausted. As long as the person meets the key criterion, which is that they must have a COVID-related reason for being unemployed, partially unemployed, or unavailable to work. And at the end of this presentation, we have an image of the eligibility checker, but a lot of your questions can be answered through the ESD eligibility checker, which is a 2-page flyer giving sort of the old laws under regular benefits still in place, but also adding the federal provisions for PUA, PUC, and PEUC. There's another new law that we need to mention that is under the Families First Coronavirus Response Act, which provides workers 80 hours of emergency paid sick leave as long as the employer has fewer than 500 employees. So this is federally funded aid, but your employer must pay you directly. You need to tell your employer you want to use this federal emergency paid sick leave. And this is 12 weeks at 2/3 pay if you have worked for your employer for 30 days and your employer has fewer than 500 employees. Significantly, your immigration status does not matter, but you need to tell the employer you want to use this, and then expanded family and medical leave. In addition, we should mention that at the state level, if you become ill or have to quarantine, you may also be eligible for workers' compensation from the Department of Labor and Industries. So our subject today is really unemployment insurance, but those are two significant fallback provisions that should be kept in mind. Secondly, I mentioned extended benefits. Okay, let's look at some of the state. Oh, I did want to mention some news. Some federal guidelines that came out that answer some significant questions that people have had. And one is, can a full-time student who is working part-time be eligible under PUA? And the answer is yes. If the student is unemployed, partially unemployed, or unable or unavailable to work because of one of the COVID-19 related reasons, then the student may be eligible for PUA. There is a requirement, there has been a requirement in the past under disaster unemployment assistance that the job be your, quote, principal source of income. However, that does not apply for eligibility for PUA. So that's significant. It also applies to people participating in Peace Corps and AmeriCorps who would not qualify for regular unemployment insurance if their volunteer site is closed down. Again, directly resulting from COVID. And secondly, there have been a lot of questions about whether, since I mentioned the requirement to receive PUA and then PUC, is that you be denied regular benefits. Does that include people who have been denied for various reasons, say because of a quit without good cause, or a termination or a discharge with misconduct? The clarification from the federal agencies is, if the individual is disqualified from regular unemployment compensation for a cause that occurred prior to the individual's COVID-19 related reason, they may be eligible for PUA. This includes an individual who has a prior fraud disqualification. And we have not seen cases where that it also includes voluntary quit or discharge cases, but we believe that that would also be included in the people who've been disqualified from use from regular benefits and then are available for PUA. So I just wanted to mention that very important message from their guidance. Talking about the Washington State changes in UI policy, we've mentioned before that the job search requirements, which are a basic requirement for anyone under normal circumstances to receive benefits, those have been suspended. The waiting week has been suspended. In addition, that's a traditional provision that bars people from receiving benefits for at least a week after they have become eligible. In addition, significant expansion of the standby program and the shared work program. Those have been expanded now so that part-time workers are eligible. They've also been extended to 12 weeks. Just want to place an asterisk there on standby because we've had so much confusion about whether people should apply under those provisions. Standby is a program that is not as relevant now because its main benefit is that you don't have to search for a job, but job search has already been suspended. So if there's any confusion to your situation, it's probably better to say that you've been laid off rather than on standby, because standby raises a bunch of different issues. So the most recent, as you probably heard from the news, there's been a significant increase in identity theft, and the Employment Security Department has been very occupied with trying to stem a huge surge in fraudulent claims. And there's various explanations, which I won't go into, but there still has to be a lot of investigation before it's clarified exactly what's been happening. Our experience is that people applying for regular benefits who are are totally qualified, have a lot of trouble getting through the security measures frequently, and yet this is still happening. So the ESD has told us they are reluctant to go into the reasons for the fraud and what kind of measures they've taken because for security reasons. But what they are trying to do is set up a series of gates to further protect the due process of individuals and businesses and to protect against fraud. One of the potential problems that could have contributed to this is that individuals were allowed to self-certify their employment. And I'm not sure how much longer that is going to, or if that's already been terminated. They are going through and looking at how to increase eligibility and deny more quickly so that people can go on to PUA. But as you may know, this week they suspended unemployment benefit payments for 2 days while they tried to respond in greater detail to the fraud problem. The other issue was brought up the week before, and I just wanted to mention it, and it's the Employment Security Department's response to the huge backlog. They received nearly 2 million claims since the COVID crisis started, and it's somewhat understandable that they've been bogged down. We've been trying to pressure them to take different actions to get some movement on this. What they're doing now is they are moving to get more people who are eligible to be paid to file their weekly claim. A lot of people don't understand that they need to do that. Many others don't understand that they need to apply for expanded benefits under the CARES Act, that is for PUA and PUC, not for PUC. If you have PUA or regular benefits, PUC should be, the $600 a week should be automatic. But there is an extension of the application. They say it's a single process, but it's essentially a separate part of the application that would qualify you for PUA, and in addition for the emergency extension. ESD also told us last week they have about 57,000 claims in adjudication process, which is basically manual processing where an adjudicator, a skilled employee at ESD, will go through each case and that's been kicked out for various reasons on eligibility issues, and try to decide if there's a way to resolve those situations by asking questions of the claimant or following up information that might be missing. They're also working on bulk clearing certain issues whenever they can. For example, one example they give is people who noted that they're a student as well as an employee typically have to show they have enough hours in their week outside of school available to work. But since most schools are canceled now, the agency has been able to eliminate that, to clear those applications. So that has somewhat speeded up the process. That's not as huge a category as some of the others, but it is something. And they have been bringing on additional customer service staff. So the thing we've been trying to do is sort of look at the top questions that we've been receiving in the webinars and in our on our toll-free line to the unemployment benefit, to the Unemployment Law Project, as a starting point, so that we can. You're welcome to come up with additional questions, but these are questions that we have often received and do need some clarification on. First, does the job search suspension mean that I do not have to be available for work? This is there's a confusing part of the law because the unemployment compensation program is set up with a basic requirement that you must be available to work. And along with that, you must be searching for work, actively searching for work. So our shorthand for this is AAA. You must be able to work, available to work, and actively seeking work. So only the last part has been suspended, actively seeking work. That doesn't mean you shouldn't be looking for work, but it does mean that you don't have to report the employers that you contacted, the elements of your job search, or necessarily keep a job search log. Those are not bad things to do, but you don't have to report them to the state at this point. However, you do have to be available to work. So it doesn't mean job search requirement suspension does not mean job optional. If you are offered a job, despite the job search suspension, the Employment Security Department generally, if it's considered suitable work, you are expected to take it in order to continue qualifying for benefits. There are many situations now, however, where people really are not available to work because they are taking care of a sick relative, for example, or their children's schools are closed and they have to take care of their children at home. They are not physically available for work, and yet they are still under the Pandemic and Unemployment Assistance Program. They are still eligible for work. So those are exceptions to the general requirement. But if those don't apply in your case, then you are expected to accept a job, including one where your prior employer calls you back, if it is suitable work. So there's still that question that has to be clarified, and that is whether the work is suitable. So you must be able and available to work. On regular benefits, there is no way around this requirement. There are, as I mentioned, some limited exceptions if your situation is due to COVID. And some people have said the job search question is still appearing on their weekly claims form, but it is optional. And the ESD has told us, as they gradually continue modernizing their UTAB system, that is the IT system for benefits and for employer taxes. They're trying to fix these glitches and relics of the old system. They are saying that that is not a condition that would make you lose access to benefits if you say you did not search for a job. If you are asked to schedule a job search review or an interview, say at WorkSource, that is also suspended. Some people are reporting they're getting that, but you shouldn't be receiving that information, and you should not have to set up a job search interview to talk about reemployment issues. Second question, I filed for benefits and was denied. What should I do? So the Unemployment Law Project, actually the bulk of our work relates to appeals of benefit denials. So what you do when you get a benefit denial, that is a determination from the Employment Security Department saying you are not eligible for benefits, is you can file an appeal. You have 30 days. You can file it online. You can also file it by mail, sending to the ESD Claims Center Appeals in Olympia. You can file it by fax. That number is 800-301-1795. And you have 30 days to do that. You do not have to specify the reason. You can include the reason, but you just need to say you disagree with the determination and you wish to appeal it. Now, there are some kinds of decisions that ESD has issued that are not technically, in the past, they have not been considered technically determinations. And this is a sort of a gray zone that ESD has not delivered on because since they're not determinations, they don't have information about appeal rights. So people have been falling through the cracks with these kinds of decisions, and we've been working with ESD to try to get this fixed because they are aware that it is a problem. There is a due process right to appeal a decision, whether it is technically called a determination or is some other kind of decision about your eligibility. Third question, I filed for unemployment last year and my benefits ran out after 26 weeks. Can I get an extension now? The federal law provides that if your benefits expired, if your benefits were exhausted after July 6th of last year, 2019, you can apply for an extension. So that would be under the emergency unemployment compensation program. And as I mentioned, extended benefits would also follow. That would give you an extra 13 weeks. Extended benefits would also follow if you have COVID-related reasons for being unemployed, with a separate application. But there are several extensions. So benefits are benefits are prospectively available for on the order of a year, if according to the guidance that we have recently received from the federal agencies. What is ESD doing to answer calls and speed claims processing? This is probably our number one reason for people calling us. As I mentioned, the ESD has its operation 100%. They are trying very hard to speed up the processing, to iron out their glitches, to hire more staff. But the situation is not looking very hopeful at the moment, just because they're very buried in this fraud issue that's bound to slow down the process even further. What can you do at this point? All you can do is keep going on to the website and attempting to appeal. If you are finding ways to do that, you can contact the Unemployment Law Project, and you can get our advice about ways to measures that you can take to help, and we will help as much as we can. If I'm called back to my job, should I return if my workplace is not safe? So the state has been very clear that if you that you are not required to return to a workplace that is unsafe. And the Department of Labor and Industries requires employers to provide safe and healthy workplaces and to implement the governor's order to prevent the spread of coronavirus. So what are the mandatory general requirements for employers? First, the employer must have social distancing, ensuring employees keep at least 6 feet away. If that's not feasible, there must be barriers or other proven prevention methods. Frequent and adequate hand washing must be required. And so facilities to provide in other words, facilities for either fixed or portable hand washing must be provided with clean and hot or tepid water, soap and paper towels. Hand sanitizer is also required to facilitate frequent hand sanitizing. Then routine and additional cleaning and sanitizing is required. That includes a housekeeping schedule, adequate supplies, and making sure that shared work vehicles are cleaned and disinfected. Establish procedures for sick workers. This is an important provision because it requires that sick workers stay home or remain isolated if they are in farm housing, and that the employer must identify and send home or isolate workers who develop signs of COVID-19 illness. And finally, there must be employee education on COVID-19 workplace hazards. So again, we go back to the question of suitable work. If you are offered a job, including an offer to return to your prior job with an employer, you are expected to accept the job as long as it is suitable work. Now, and as I mentioned, there are some reasons why you would not be available to do that under the pandemic unemployment assistance program of the federal bill. But if the workplace is not safe, we do not recommend that people return. You do not have to risk your health to return to the job. So these are the requirements that are that have been set up by the Labor and Industries Department. And there are additional recommendations that you can consult at the federal OSHA site, Occupational Safety and Health Administration, to find other measures that all employers can take to reduce workers' risk of exposure. So you are not expected to return to work if you can show that it is unsafe. However, if the employer is meeting these standards, then people are expected to return to that job. Another question, how much part-time income can I make without losing benefits? So this has been a very frequent question we received because it's very common for people to have a little bit of income once they become unemployed for various reasons. Maybe they were already a part-time worker. Maybe they're a gig worker and they have some extra income. It is possible to receive some income as long as you report it to in your weekly claim to ESD. However, your benefit will be adjusted, and the calculation for that adjustment is available from ESD on a chart called the earnings deduction chart, and it clarifies that if you make over a certain amount, and it gives what your income is and what your benefit is. If you make over a certain amount compared to your benefit, then your benefit ends up being zero, then you no longer qualify for pandemic unemployment assistance or for benefits. So that means you would not be qualified for the $600 a week under PUC. So if you need assistance in finding that, we can refer you to the earnings deduction chart to show you how to calculate that. I wanted to mention also about the unsafe workplace issue. It is against the law for any employer to take any adverse action such as firing or threats against a worker for exercising safety and health rights, such as raising safety and health concerns to their employer, in addition to filing a safety and health complaint. And the calculation for how much income you can make without losing benefits. Just very quickly, take $5 off of your gross earnings, multiply by 75%, subtract that from your benefit amount. If that is less than zero, then you have no benefits coming in and you cannot continue receiving pandemic unemployment assistance. This is the chart that I wanted to refer you to. It's very helpful for understanding what benefits are available and what you need to do to qualify. The most important, on the left, you'll see all the requirements that you must meet in order to be eligible for regular unemployment benefits. And again, just to repeat, you must be denied regular unemployment benefits in order to get the benefits listed on the right side, which are under PUA and PUC. Do I qualify for expanded unemployment benefits related to the pandemic? All of these provisions are part of the package, which the requirement which you must meet, which is your unemployment, your partial unemployment, or your unavailability must be related to COVID-19. So you can apply if you're working less than normal because of COVID-19. If you didn't work 680 hours, if you were diagnosed and are still severely ill but with COVID, but not only that, if you're showing symptoms and are either waiting for results of a test or seeking medical attention. If you're at high risk and a medical provider has told you to stay home, caring for a family member with COVID, have a family member who's showing symptoms and is seeking medical attention. So there is some leeway here for situations that are not clarified 100% with a medical provider's recommendation. So this is very helpful for understanding those provisions. Also the additional one about taking care of children because children's school has been closed. Again, or because you are unable to find childcare. Again, it must be because of COVID. So at this point, we are welcoming your questions, looking forward to hearing what you would like clarified. So John, is there anything you wanted to add to what I said about these other frequently asked questions?
It's just that it's been very difficult in terms of law practice in the area of unemployment law when you come from an area where there are very few changes over the years and then having to deal with the law. And the big issue is access, and that we haven't been able to intervene on individual persons' behalf in most cases. And we urge people to contact their state senator and their state representatives, perhaps, to get a call back from ESD or some sort of intervention for help with the processing, because that's been the big issue, and it's something that we have been trying to help people with, but the response has been mixed. And people who contact their state senator and state representatives have gotten back to me and said that that hasn't worked, move their claim along.
Okay, great. So we're going to go ahead and get started with some questions. As usual, we have quite a few of them, and we'll get to as many as we can today. If for some reason we don't get to your question, please feel free to call in to the Unemployment Law Project. We have been able to increase staff during the COVID-19 era, and we're happy to be able to answer your questions there as well. So let's begin with I have several questions up here, John, related to the delay in hearing back from the agency. One person says they've had their claim pending for 6 weeks and haven't heard. Another person said they filed a month ago and haven't heard anything back. Do you have any news for us on what we should be seeing in terms of response times and what the agency is doing about that?
Well, they have announced this Operation 100 to get through all the claims, but our office is still experiencing calls. We're getting hundreds of calls from people whose main issue is simply that they cannot either file a claim or complete their claim, or once their claim is filed, it is pending. So it's a problem, and I think that for some people, the language barrier is a big issue because there's very unequal access here. Online applications are in English and Spanish only. Otherwise, any other language, you need to use the 800 number, which is hard to get through. And also, there is a problem with even computer access right now with people who cannot go to a WorkSource office or the public library for that. So those issues need to be addressed, and the state has been slow in responding.
Okay, great. So,
one thing to add, that unfortunately that is going to be aggravated by the fraud situation. It's not a good situation.
okay, a question from someone who submitted their application or their claims and has gotten some requests for more information. One question was, what prevented you from filing your weekly claims on time? And another one, why do you feel that you were not at fault for this overpayment? Obviously been asked about an overpayment situation. They say they made a mistake and submitted claims for the past several weeks, I think late. For example, for the May 3rd through 9 claims, all Saturday the 16th, April 26th, May 2nd claim, Saturday the 9th. Is this a late submission, and how do I answer these questions?
Well, I mean, give the reason why it's late. And I think for most people, the answer will be that the whole system has broken down and that it's been impossible to file on time. That should be a good reason for the lateness. And then the question about a potential overpayment, for most people, the answer should be, I provided all correct information when I filed, or if I didn't, it was corrected.
Okay. Next question. This person was receiving benefits, but then had to refuse work for a good reason. They reported that on their claim. They keep receiving money now, and haven't heard anything. Will they know when will they know if there's a problem? They're worried because, obviously about an overpayment situation if it later gets denied.
Yes, this is a new question I'm getting now frequently. They will analyze whether your refusal was for good cause. And under the current law and law as it's been in the past, if you're getting unemployment, you don't have to accept an unsuitable job, and that could be due to the hours, the safety, the health issues you may have. So a job that normally would be a suitable job for you, if they're not providing safety equipment, that would be unsuitable. Or a job that normally would be safe for you to work at, your health issues or family's health issues may make that job unsuitable. There will be a determination made. If benefits continue to be granted, that's fine. If they find that you rejected a suitable job offer, file for a hearing. When you get your hearing, call ULP for help. And as far as repayment of benefits, that could be a separate issue. If there is benefits that were paid and then they found it wasn't, I think that can be an issue that can be fought over in the hearing that would come. But right now, this person is in good shape because they had a good reason for rejecting the job and they reported that correctly.
Okay, very good. I've got a couple of questions from people who are receiving emails from ESD asking for more information. Just a quick precursor question to those, John. Is there any way that people can rest assured that these are legitimate emails from the department as opposed to something fraudulent?
Wow, that's a new one. I know that people can fake email addresses. Usually, when I get an email from ESD, it's a response from a specific person, an administrator, for example. But I know there's potential for mischief, I'll say. It's a good question. Anne, I don't know if you have any thoughts on this.
I don't. One basic thing is check to see that the email has the domain of esd.wa.gov. But of course, as John said, there are ways to get around that, but that would be a start.
Yes.
Okay. On to those then. One person on their own My ESD homepage under Manage My Account, they happened to scroll way down and saw a red triangle with a note saying, "We need more information from you. You have until May 27 to respond." When they clicked on this, they were required to check that they would be truthful. And then the next page asks, "What week do you wish to claim?" But they've already claimed all their weeks accurately, so now they don't know what to put. Have you heard of this or any advice for that?
I've heard variations on it. I think the advice is you can't get double benefits, so there's not a problem there if they just reiterate what weeks they have already claimed and what weeks they want. So I don't think that's a problem. If there's a way to add a little explanation, like a little note saying, "I've already claimed for these weeks, and these are the weeks," that would be fine too. There isn't an issue of people sort of double claiming, and this question's come up a lot with these separate programs, the regular UI versus the pandemic unemployment. If you're an independent contractor, if you're not eligible for the regular unemployment, you may be eligible for the ones for the self-employed, but in no way will you get both at the same time because it's either one or the other.
Okay, very good. Just so everyone knows, there's a lot of information that's been posted in the chat, phone numbers to call, etc. So just pay attention there as well. Next question. Last Friday, I and many others received an email prompting me that there was an issue with my application. The issue asked me what dates are you claiming, then why I didn't file my claim on time, and then a statement about possible overpayment. There was 1 week where I received PTO, but I did indicate this accurately and they paid me anyways, not sure why. What can I do about that? And I didn't actually file anything late and do not believe they overpaid me based on my own mistakes. Any advice there?
Well, again, report correctly. If there's a determination of notice of overpayment, file for a hearing right away. They frequently give people these warnings, so you have to pay back and all that. And that's actually typical. of the unemployment system. I don't agree with that because I think it scares people from asserting their rights, but that's what they do. Again, this sounds like similar to the other question. The sort of general rule that you can use is if you're asked for information, give it. If you need to correct information, correct it if you can. But you know, I wouldn't worry about overpayments if you're reporting accurate information and they grant you benefits. Benefits should be granted, and even if there's a dispute, there's always a possibility of what's called a waiver, where and our office has been doing these cases for years, where benefits were paid, and then a person can appeal that, and due to financial hardship or other circumstances, not have to pay it back. I don't want to go into the complex list of other reasons, maybe, but it is something that can be fought if it gets to that down the road. But I think people should apply for the benefits they need and report accurate information. And it's their, if you're reporting accurate information, it's their duty to then process claims accurately. And that's why, you know, so many people can get overpayments waived, because they often don't do things correctly.
Okay, very good. You know, as we start to integrate back into the workplace, I'm sure some people, due to personal circumstance, will be still concerned about entry back into a potential situation where they can get exposed to COVID. Along that line, what information would a doctor need to provide to say that you're medically high risk to return to work once your job category is okayed by the state to return?
Well, I'm sort of relying back on, you know, some basics of during unemployment claims we've done over the years involving medical issues. It's for the doctor maybe to be specific about what the diagnosis is and what the link is to it. It's always good for doctors to give a basis for the knowledge, you know, to say that they've been your doctor for so long, or they've examined you, to establish it as, you know, being, you know, a sound opinion. But now there's so much information out there, I can't even keep up with it, about what are the high risk groups and what are the risks. But I think making that connection between the workplace and the risks, a lot of these employers, of course, will, you know, there are some employers who don't believe in science and who may think this is all a hoax, and might not be receptive to that, but people should not put themselves at risk. And would you have any other suggestions about what can be?
Yes, just one point.
Know?
If you notice on the eligibility checker, if you have a chance to look at that, there is latitude for a slightly vaguer certification or letter from your provider, your medical provider. It says, are you at high risk and a medical provider has told you to stay home? That's one way you can show that it's a safety issue for you. But the second one is, if you are at a high risk, are you staying home based on medical advice about the dangers related to your risk? So if your medical provider has previously provided advice against doing certain things, it does sound like that would qualify you under the PUA guidelines as they are written now for COVID-related illnesses or risks.
Okay, onto a completely different topic. Does having a criminal record affect eligibility for regular unemployment benefits?
Short answer is no. The only, well, I'll just say a few things. That if you're on a kind of probation or parole or house arrest, that you cannot leave the house, that's been considered to be you being not able to work. That's a rare circumstance that has come up. But the only disqualifications I've seen have been fraud findings within the administrative realm of unemployment. That if somebody, like, and I'll give this as an example, somebody was filing for unemployment, and they took a job knowingly, and they knowingly failed to report that they were earning income that week. So they lied every week saying, I did not work. And then it was it was caught, of course, that they were earning, $1,000 a week in a week that they said that they were unemployed. They would not only have an overpayment, but there would be a period of disqualification for that. That is not a criminal charge, but that's unemployment administrative fraud that would then keep that person from filing a new claim, make them ineligible for a new claim for a certain period of time. There are different ones, disqualifications periods, whether it's based on the first, second, or third time it happened, how many weeks you were kind of kicked out. So if you had a new valid unemployment claim, you would be denied for that new claim after that type of fraud.
Again, that is for regular benefits. The federal government has clarified that if you're disqualified from regular benefits for a cause that occurred prior to the COVID-related reason, you may be eligible for PUA, and that includes if you have a prior fraud disqualification. So just wanted to make that one note.
Yes, please. Thanks for adding that.
Very good. Here's a little bit of a long one. This person is a sole person LLC. They filed their unemployment application as an employee of their own LLC, and it seems now that was the wrong way to file. The next screen on the application was for self-employed people. They then received paperwork from ESD asking them about themselves and directed to the employer. This seems wrong. Do they need to, they said that, this seems, and are asking, do they need to contact ESD to change this somehow? Should they just be filing as self-employed, or how does that work?
Good question. Again, if you file as self-employed, as long as you're providing correct information, again, you're providing correct information, that would be fine. I don't know what the outcome would be in this case. And under normal circumstances, when you could call the unemployment 800 number and get through to someone, this would be easy to kind of resolve and get questions answered. So in that case, I'll go back to my recommendation to contact your state senator and representatives and see if they can have a staff member intervene on your behalf in order to set up contact with ESD so that can be resolved.
Just to add one thing, if you are paying unemployment benefit taxes as an employer, even if your employee is yourself, you should be able to qualify for benefits.
Okay, very good. A related LLC question. Another person is the sole owner of their LLC. They just received notice that they received a PPP loan, but they're currently getting unemployment extension benefits as they were employed for 3 months in 2019 and had exhausted benefits. How do they handle filing claims during the 8 weeks of the PPP loan? And then do they get to restart on week 9 after the PPP runs out?
Well, and I'd like you to take this one after I give my 2 cents. I mean, I think, again, if you're getting income, paid income from an employer, your employer, when you can claim unemployment for that week, but then when they ask you what your income is, report the full amount, and that should be fine. And then if those funds run out, that should, of course, limit your availability. And then, of course, when that money runs out, you would be able to get regular unemployment after that. But over the years, I've talked to people who had trouble reopening a claim when they've closed. Like if somebody would call me and say, well, hey, John, I'm going to be paid full time for 3 weeks, but that's going to be over in 3 weeks. Should I close my claim? I often say, well, claim, but then when they ask you if you worked, tell them that you made, $1,000 or whatever you made. You won't get unemployment for that week, but then 3 weeks later when you're unemployed, it would be easier to do that than to close the claim and then reopen. But Anne, would you like to?
Yeah, this
Yeah.
sounds like a technical issue, but I think it's basically the same issue as when anyone would try to attempt to make a claim for unemployment when they actually have an income. So that's not something that is allowed. As John said, you can avoid any problem. You should be able to avoid any problem by reporting that income. If you do report it, it's likely that you will not get any benefits anymore because it's subtracted as an earnings deduction from your benefit, and you would be below zero benefits. But that should not expose you to a fraud accusation. So it's really not, it should not be a different issue from anybody trying to get both benefits and a salary at the same time.
But when that pay runs out, then you should qualify.
Right.
Good. Very good.
Okay. This one seems a bit concerning. Someone says the ESD is sending secure messages directing people to upload a document with copies of one's social security card and either a driver's license or passport. This works, they say this works for people like me who can put their hands on their social security card and have a scanner. But what about everybody else? But I would ask the question, is this legitimate? Is ESD asking for this kind of copies, or should they be worried that this is a phishing expedition?
Well, I've been hearing about it, from many people, them being asked. I think whether it's really necessary is not. I've had people who've been U.S. citizens their whole lives, lives and worked in the U.S. for over 40 years, are being asked or having their ability to work or their immigration status questioned. So, yes, they can ask, and the access issue of people without computers and scanners. This is, I've had many calls from people like that who may be able, the kind of person who may be able to borrow their friend's computer to make a claim, or maybe use their cell phone, but they have no access to a scanner or knowledge or how to use that. It's very disturbing, and this is ironic. This is the problem. We've talked about, or it's been noted that there have been issues, problems with fraud. For every fraud case, I bet there's many more people who were denied wrongfully, for not having the right identification or something when they are fully eligible. So it's when there's security measures, it goes both ways. Fraudsters can get through. On the other hand, people who have a legitimate claim can be denied. Anne, would you like to add on that?
Yeah, this is not something we can necessarily answer, but we can ask ESD if they are sending these requests and if they're legitimate. They have cranked up their security measures significantly, and they are unwilling to give all the details, but they should be able to tell us whether these kinds of requests are indeed legitimate.
And call your state senators, state reps, and the governor's office, email the governor's office on these issues as well, both for individual cases, but just as a general policy of how they are operating.
Right.
Okay, we probably have time enough for one or two more questions here. One is, this person was laid off due to COVID, but for the last few weeks, they've been doing Postmates. I assume that's some kind of employment, because they didn't realize they qualified for the PUA. They recently applied, and now their application is under review. The weeks they worked as an independent contractor, I assume again for Postmates, says I have excess earnings and will not receive benefits for those weeks. I'm concerned because I will be denied benefits because of my self-employed income, and I would also like to know if I should still get paid for weeks with excess earnings.
Okay, so Postmates is a food delivery service or other delivery. People are paid as independent contractors, so that income would be reported, and if it goes above your regular weekly benefit amount, then you would not get the extra $600. So it would depend on how much work you got from that. If you again were earning more than that, but if your income slowed down or you weren't getting the jobs, then of course file for unemployment. You could keep the claim open and keep filing as long as you report that income correctly in the week that it's earned.
Okay, one last one. A clarifying question. Do all of the COVID-19 related reasons for good cause to quit also apply to a refusal to accept a suitable job offer?
Well, I'm not aware of a COVID-19 for refusing, for quitting. The reasons for quitting are under the statute of 11 reasons under regular unemployment. But I think the issue is refusing work. And do you have anything to add on that? Are there new good cause reasons for quitting?
No, there aren't. All the COVID provisions relate to the federal bill, and they have not changed the state bill, which has only 11 good causes for quitting. But of course, one of those is a threat to safety, worker safety, or health. So as I kind of outlined, there are several reasons why an employer might not be able to meet the conditions, say, that the Labor and Industries Department is set up. Those would be considered good cause to quit. It may be something you have to appeal, but right now it's only related to declining work that is unsuitable.
Okay, great. Well, that brings us to the end of our hour. We're here every Monday at noon. Please tell your friends. If you didn't get your question answered today, please feel free to call in to the Unemployment Law Project. The number is up in the chat. So please let us know if you have those kind of questions. Otherwise, if your question can wait, you're welcome to come back and ask it next week as well. So again, we appreciate everybody's participation. Good luck out there. Stay safe and healthy.